Did you understand by pleading true to violation 14G, the court could find it true, grant the motion, find you guilty, sentence you up to 1 year in the Bexar County Jail and up to a $4,000?
Right from the start, the judge lays out the stakes, and they're heavy. A single true plea here isn't just words. It's the difference between freedom and a year behind bars. Watch how every answer from this point forward becomes critical.
099, State of Texas versus Marquise. How do you pronounce your last name? Bozier. Could I have the parties announced for the record for the state?
Ashley Jones.
Defense.
Zachary Munoz.
And are you Marquise Tyree Bozier? Did you review the documents entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and state's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Marquise Tyree Bozier who was placed on deferred adjudication in 2022 CR 6099 on December 5th, 2022 for a period of 2 years for the offense of assault bodily injury? Is that you?
Yes, ma'am.
All right, state.
Yes, Your Honor. I'm sorry. Give me just a minute.
This is where the long-term impact truly.
The state is proceeding on violation of condition number 4. Would you like me to read that?
Yes.
Violation of condition number 4 on the August 9th, 2024 supplement to the motion to enter adjudication of guilt. In Bexar County, Texas, the defendant Marquise Tyree Bozier, did then and there fail.
And there it is, a rare courtroom stumble. The prosecutor accidentally reads the wrong violation. It may seem minor, but mistakes like this can cause confusion, raise eyebrows, and shift the courtroom energy instantly.
To report to the supervision officer as directed for the months of April, August, December of 2023, and March 2024. Violation of condition.
How do you plead to that, true or not true?
And Your Honor, I do apologize. The state is going to waive that condition. I read the wrong condition.
Okay.
So the state will be proceeding on violation of condition number 14G, that on or about the 23rd day of April 2024 in Bexar County, Texas, the defendant Marquise Tyree Bozier did then and there fail to comply with the instructions of the Battering Intervention and Prevention Program, or BIP, as directed by the head or authorized personnel of that agency, in that the defendant did not provide proof of attendance in violation of condition number 14.
How do you plead to that, true or not true?
And the state will waive all remaining conditions in all supplements and original.
Any objection to the waivers?
No objection, Your Honor.
Did you understand by pleading true to violation 14G, the court could find it true, grant the motion, find you guilty, sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine? Knowing that, do you still wish to plead true to 14G? Court will find 14G true.
This is the moment many defendants freeze. Pleading true means surrendering the shield of deferred adjudication. It's a gamble, admit the violation, hope for lenience, or risk the full weight of sentencing.
Is there a proposed agreement?
There is, Your Honor.
Yes.
That agreement is to grant the state's motion to enter adjudication of guilt, adjudicate the defendant guilty, and sentence him to 237 days in the Bexar County Jail. That would be a JSAT, and we would ask that time and money.
All right. What has he done on probation?
Your Honor, my understanding is he did complete some of the courses. And he did pay some of the fines and fees.
Did he complete anything? Did he complete the batterers intervention
No,
program?
Your Honor, that's why he pled true to that one. He enrolled, unfortunately, as of course well aware, it's quite time consuming and it's quite expensive. And my client, unfortunately, he has a wife and stepchildren that he is the main financial provider. Unfortunately, his wife came down with an illness to where she was unable to work, so he was.
Is there any proof of that?
I don't have the proof for today, Your Honor.
Did he tell probation that he was having these issues?
I'm not aware if it's not notated in the.
Did you tell? You want to raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. State your name for the record.
This right here changes everything. Courts often show mercy when there's documented hardship, but without proof, it becomes a story versus a requirement. And in probation, if it's not reported, it doesn't exist.
All right. Did you tell probation you were having difficulties? Did you tell them about issues concerning, is this your wife?
Yes, ma'am.
Did you tell them about that?
No, ma'am.
Okay. Did you complete anything on probation?
I believe it was, I had 2 courses. The BIP was the only one that I didn't complete, but everything else I completed.
All right, so you completed the DOEP course? All right, the main course is the BIP, because that's the battery intervention course.
Yes, Your Honor. No, we understand, and that is why, he has been in custody for 237 days. That's why we're asking. It's pled true to that violation. We're asking the court to accept that, the current agreement of 237 days and hold that as a judgment satisfied for this case.
All right, and who is the,
The complainant is an ex-girlfriend from years ago, back in 2022 or earlier.
so has he had contact with her?
I've spoken with him prior, and no, he has not. He can go on the record, of course, and testify saying that as well.
And Your Honor, just to clarify for the record,
Right from the start, the judge lays out the stakes, and they're heavy. This is the hammer dropping. Once the judge revokes probation and enters a family violence finding, the consequences become permanent, from firearm restrictions to future sentencing enhancements. This is where the long-term impact truly hits.
I just wanted to make something correct for the record. At least in one of the supplementals, it does allege that there is a violation for not completing the supplemental, for not completing the drug course. That is an allegation that the state is waiving, but I just wanted to have that confirmed.
All right, the court is going to grant the motion, find you guilty, revoke. There's an affirmative finding of family violence. There's to be no contact with the complainant. That's Danesha Gray, Danesha. There's going to be credit for any time served. The court will sentence you to 1 year in the Bexar County Jail. All right, did you review the document? And the court will not do a fine. Did you review the documented trial court certification of defendant's rights to appeal with your attorney? Did you understand it and sign it?
But is this justice served? Or a system too rigid to account for real-life
The
hardship?
document that we only
Right
released.
from the
It's
start,
fine.
the judge lays out the stakes, and they're heavy. A single true plea here isn't just words. It's the difference between freedom and a year behind bars. Watch how every answer from this point forward becomes critical. V1. And there it is, a rare courtroom stumble. The prosecutor
All right, did you review that document with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
You have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you were on deferred adjudication. Because this is a conviction with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
You're welcome.
Your Honor, if I can just explain to him what just
Sure.
occurred so you understand.
Yes.
It becomes a story versus a requirement. And in probation, if it's not reported, it doesn't exist. Before, this is the hammer.
Who's here on Darren Johnson?
The judge revokes probation and enters a family violence finding. The consequences become permanent, from firearm restrictions to future sentencing enhancements. This is where the long.
All right, have you all conferred with Ms. Ferguson on a jury trial date?
We did not, Judge.
How long do y'all expect this trial to last?
3 days, longest.
All right, Ms. Ferguson, I need a jury trial date on Johnson. Ms. Johnson, because there was a snow day, we can't have your jury trial. Oh, I love the outfit you're wearing. You always dress appropriately for court. I appreciate it. So we're going to do our best to get your jury trial date. So what date?
April 1st.
All right, so it's going to be April 1st.
Thank you, Your Honor.
All right, thank you so much.
Thank you, Your Honor.
You're welcome. Once you sign the reset form, you excuse.
Thank you, ma'am.
The prosecutor accidentally reads the wrong violation. It may seem minor.
Can we go on the record? That's
Sure.
fine. It's misremembering the conversation we had previously.
Oh, what, you want to go on the record with that?
Just
Attorney-client privilege.
Yeah, you're right.
All right, let me see him. Could you come down, sir? Let me explain some things to you.
He's failing to understand the jail credit will essentially, if he's given 2 for 1.
So here's the thing. With motions to revoke, your attorney in the state, they may say, oh, we agree that this is what we want to happen. But because that is a contract with the court, it's not a contract with your attorney or the state, I don't have to follow any agreement that you have. With regards to credit for time served, legally, I'm bound to give you credit for any time that you've been in custody. So I sentence you to the maximum amount that's allowed, which is 1 year.
One missed program, 1 year in jail. It's a tough reminder. In the world of probation, the smallest misstep can become the biggest setback. But is this justice served? Or a system too rigid to account for real-life hardship?
Bexar County Jail. How much time does he have in?
238 days.
All right, you have 238 days in. What I can tell you is I'm not in charge of whether you receive 2 for 1 or 3 for 1. That's the jail. Normally, the jail will give people 2 for 1. So every day that you are in custody, you get credited for 2 days. Do you understand?
Yes, no.
All right. Do you have any other questions?
This is the moment many defendants freeze.
No.
Thank you, Your Honor.
Thank you.
Thank you.
You're welcome.